You're live.
So, Damien, let's just pick up right where we left off, looking at the laws that apply to ag workers in Vermont. Now we were talking about federal laws.
Yep, and so when we left off, we were just finishing up wage and hour. So we're gonna move on to child labor. So let me just pick up my screen here. There we go. Sorry about that. All right. So the good news about child labor is Vermont's law is essentially written as it has some general provisions in it, but then says follow the federal law. So the two big things to remember about Vermont law, and I've included, I believe, a document on the website that provides more detail on child labor, is no child under 18 can work in an occupation or with machinery that's deemed to be hazardous by the Commissioner of Labor or the U.S. Secretary of Labor. And then there's limitations on hours and time of employment for children under 16. Those generally apply to you can't work during school hours. You can't work more than 40 hours a week. And there are some limitations on the hours of the day that you can work in agriculture. Those limitations are waived if you are an actor or if you are a bad person at a baseball game. So these unique carve-outs we have, totally apropos of nothing here, but yes, actors and actresses do get special dispensation to work late. So the federal FLSA is where you find the federal child labor laws. Child over 16 can work in any farm job at any time. Children who are 14 or 15 can work outside of school hours in jobs that are not deemed hazardous by the U.S. Secretary of Labor. And just to give you an idea of what hazardous jobs are, they're things like working with power takeoff on a tractor, working with mechanized harvesting equipment, et cetera. So basically think heavy machinery working on a farm. Children are generally not allowed to work operating the heavy machinery. Or for example, riding, standing on the tractor next to the driver or something like that. Children who are 12 or 13 are allowed to work outside school hours in non-hazardous jobs with parental consent on farms where no employees are subject to the FLSA minimum wage requirements. So these are those very small farms or the smaller farms. They could actually be a significant number of Vermont farms. And then local children who are 10 or 11 may hand harvest short season crops for up to 8 weeks between June 1 and October 15 if the farmer obtains a special waiver from the federal DOL. And children at any age may work in any job on a farm owned or operated by their parents. So in other words, if you're working on your parents' farm, these restrictions do not apply. But if it's not your parents' farm, then you're subject to these other child labor restrictions. Questions? This one's a little more straightforward.
So the federal law, we see that it's fairly lenient, maybe one way to describe it, in terms of allowing children to work on farms under those conditions. Does Vermont law?
Vermont essentially follows the federal law. Yeah, so the way the Vermont law is phrased is it has a couple of general restrictions, such as the limitations on hours and time and the discussion of non-hazardous occupations. But then what it says is it's the intent of the General Assembly that the state will follow the federal guidance on this. And so then if you look at the information sheet, which I'm pretty sure I provided to Megan to post, it includes basically, it just combines everything. So you can see it has a list of hazardous occupations, et cetera. And so you can get a sense of, what's considered hazardous what's not considered hazardous, what are the restrictions, and it goes into much more depth than this slide. Okay. Next is, that's a good segue into occupational safety and health. So for those of you who don't know, Vermont is what's called a state plan state. So federal law controls occupational safety and health. There are 29 states that have a state plan that's approved by the federal government. And what that is basically the state will enforce the OSHA law, and they agree to enforce standards that are at least as protective of health and safety as the federal standards. For Vermont, because we have a staff of half a dozen or less in our occupational safety and health office, that essentially means we follow the federal standards. We don't have capacity for our own separate rulemaking, which requires folks like industrial hygienists, et cetera, who go out and they figure out workplace safety standards and then write their own rules. So we just adopt the federal rules wholesale, which makes it easy. So federal OSHA applies to farms that employ 11 or more. Well, it applies in a couple of different instances. First, there's what's known as the field sanitation requirements, which apply to farms that employ 11 or more hand labor workers on any day in the last 12 months. So any single day in the past year, if you had 11 or more workers doing hand labor, that can be planting, weeding, picking, et cetera, in the field, you are required to provide a toilet facility, potable drinking water, and hand washing facilities in a location that is easily accessible in the field, and to provide reasonable time to use those facilities. So it's basically allowing your workers to have easy access to bathroom and drinking water during the workday out in the field. There are also specific standards for certain hazardous substances. Think pesticides in particular, or herbicides, and then agricultural equipment. Think rollover protection on tractors, et cetera, as well as signage around things that could be hazardous if you're wearing loose clothing or that have blades operating that could be hazardous to you. So there are various requirements on that. And then there's an overall general duty to provide a workplace free from hazards that are likely to cause death or serious injury. Generally, the enforcement comes through an actual standard rather than the general duty statement, because the standards are really clearly established. You know, if you're working with a substance that contains this particular chemical, you have to provide respirators, you have to provide eye protection, et cetera. So does that make sense?
And Justin Tenterman.
Thank you. When you say that the state just enforces federal standards, are you speaking specifically for agriculture or?
Everything.
Everything.
So what our state does is when federal OSHA adopts a new standard, Vermont OSHA or VOSHA, a few months later, we'll adopt the same standard. And they'll go through the state rulemaking process and then adopt the standard in its entirety. There are, I can think of in my 10 years of doing this job, I can think of no instances where the state deviated from the federal standard, except in the names of who you contact, because you're not contacting the federal office in Boston, you're contacting the Vermont office here in Montpelier. So that, but apart from that, we adopt, standards on things like beryllium and cadmium, standards related to work in shipyards, as well as rollover standards, standards for when you're working below ground in construction, et cetera. So it's across the board. When the federal government issues or updates a standard, Vermont follows to stay at least as effective as the federal government. The main difference for Vermont is that instead of having a federal regulator who may not understand Vermont or understand some of the realities of the workplaces here coming in to do enforcement, you have a Vermont regulator who can come in and using their discretion can devise more reasonable approaches to remedy the situation and the issue. And so that's why 29 states have gone to state plan, is because you see more localized enforcement produces more localized solutions to the safety issue, or more of a willingness of the state regulator to try to work on prevention rather than significant sort of penalties or something like that. So it's more of a carrot model than a stick model that you might see.
Thank you for preempting my next question.
Yeah. So, and it is, it's a discussion that we have frequently. Why do we do this instead of the feds? And it really comes down to that. The federal penalties are run into six figures, which, as you can imagine, for a lot of small businesses in the state that would be it.
Yeah.
And instead having a local regulator saying, we're going to issue a nominal penalty and work with you to remedy the situation, keeps business going, keeps the people employed, and also ensures there's a safe working environment.
So the first bullet point there under the federal farms that employed 11 or more hand labor workers.
Yeah.
So then if you employ fewer,
You're not
You're
subject to the field state
not subject to-
sanitation. Yeah. It's called the field sanitation standard.
okay.
So you're not subject to that. It doesn't prevent the farmer from providing toilet facilities or adequate breaks, et cetera. It's simply that you're not subject to that standard. Some of these other requirements will apply more broadly. For example, rollover protection, hazardous substances. And navigating this is going to be something that the farmers have to deal with. They have to figure things out. Good news is for some of these things, because the standard is ubiquitous, it's national, you'll find that the products you're buying satisfy the safety standards as you're buying new products, because no farmer is allowed to operate, for example, a mechanized harvester that doesn't meet these standards. So if you're selling the harvesters, farmers are already asking that you provide them with something that meets the standard, whether it's in Nebraska or in Vermont. So
We're thinking, at least partly through the framework of how do agricultural workers get treated compared with other workers, and how the law, federal and Vermont law, treats them separately in some instances. I'm wondering, I'm just curious and not expecting you'll have the answer, but maybe we could look into it later, whether there are similar stipulations for other industries. So is the 11 or more, is that unusual to farms, to agriculture, or are there, like manufacturing businesses, do they have to provide, restrooms if they have fewer than 10 employees?
So there is a Vermont law on that issue, which just says that you have to provide reasonable opportunities for bathroom breaks. No clarification on what that means. This actually is something that varies by state. But field sanitation is kind of a unique standard to agriculture. The two other standards I mentioned here, it's worth noting that these are hundreds of pages long. And 29 CFR section part 1910, that is a general industry hazardous substance standard. And it covers things like beryllium, cadmium, and other things like that, some of which you may encounter in agriculture and others which you may not. And then 29 CFR 1928 is actually, that's specifically agriculture. Sorry about that. So that is another one that's unique to agriculture. The stipulation on breaks is going to vary state by state, as will the exceptions to it. So I know Vermont is very general. Other states say for more than 6 hours, you have to provide a half-hour meal break, or you have to provide certain 15-minute breaks, et cetera. Vermont is less prescriptive on that front than other states. They just say you have to provide reasonable opportunities, and that does apply to all employers. So a farmer with, say, 3 employees still has to provide reasonable opportunities. They don't necessarily have to provide the toilet, hand washing, and drinking water in the field. It could be you have, time to go back to the barn where I have those facilities, or, to another building where I have those facilities. So.
Representative Superintendent.
Yeah, I'm just wondering, as we're considering this, where we as a collective would like to consider the intersections on not just the impact that it has on the individual who is engaging in those labor acts themselves, but also the impact on public health, potentially considering those risks of not having access to hand washing when we're considering that these are agricultural workers working with food and wanting to prevent things. So considering it, yes, it's important for employees to have access to that, but also there are additional things to consider of why it is important to have those at hand as well. That seems like a good thing to keep in mind as well.
Right. So yeah, there's a lot of, I think with all of these, you'll find that there's a lot of different sort of complicating questions here you get into. And then I want to also emphasize, I'm focusing on the employment labor standards. There's also moving away from hand washing, so EPA regulations, etc. And other things farmers may encounter. Certifications that farmers seek for pesticide-free organic practices, etc., are all going to be layered on this. Some of them are imposed by the federal government. Some of them are self-imposed by choosing to seek a certain certification. But in addition to that, you also have public health consequences. You have costs that are that you need to consider too, in terms of what's the cost benefit here, and are there other ways to get there? So I can't take a position on any of these or raise opinions, but it is worth noting that we're looking at sort of a narrow piece of this. And I think it's just worth emphasizing that the advocates and representatives of farmers and farm workers that you're going to hear from at future hearings are going to be able to provide you with a lot more context for these issues than I can provide. So overall sanitation practices on, for example, a farm that's handpicked, but only employs 4 people. How do they address that? What are the costs? Is there a way that they get around, for example, possibly not having hand washing facilities in the field? Is there another way that they approach that? And is that effective? So these are all things to keep in mind.
Okay, so we can keep going.
I feel like every slide, I just emphasize how much more complicated this is getting. Discrimination protection. So this one is pretty simple. The Fair Employment Practices Act, which it provides broader discrimination protections than any federal law or combination of them, applies to all employers in Vermont without exception. I should clarify that without exception. All employers are covered. Certain employers, particularly religious employers, have some limited exceptions there with respect to certain areas. For example, you can't require a religious employer to hire someone of any religion to work in a religious role. Similarly, there are certain religions that have opinions on or stances on same-sex marriage that will make certain employees incompatible with that religion. So that said, for farms, they are covered, period. Doesn't matter how many employees. They are not allowed to discriminate on any of the covered bases. Under the federal law, it is very different. So the Equal Pay Act applies to the farms who are covered by the FLSA. As we talked about, this means that small farms are not required to comply with the federal Equal Pay Act they are required to comply with Vermont equal pay standards, which are more protective. Title VII of the Civil Rights Act, which is discrimination on the basis of race, religion, national origin, sex, and I'm forgetting one. That one applies to farms with 15 or more individuals for each working day and 20 or more calendar weeks. That is a really complicated way of saying that you have 15 individuals who have worked for a full work week for you in at least 20 work weeks. So you can imagine for a farm that has a seasonal surge, even if they're over that 15 employee threshold, they won't hit this because their seasonal surge is 8 weeks or 6 weeks. Age discrimination in employment. This protects people over 40 from age discrimination. Again, Vermont law is more protective. It protects people down to age 18 from age discrimination. This applies to farms that employ 20 or more individuals for a full week and 20 or more calendar weeks. And then the ADA, again, is the 15 or more for a full week and 20 or more weeks. The bottom line with this is that the federal protections are likely not to apply to a Vermont farm, but the state protections kick in. So with discrimination law, there really is no difference that I am aware of between an agricultural worker and a worker in any other industry. The next one I'm going to touch on is sick leave. This is a Vermont only. There was a federal sick leave law briefly during the COVID-19 pandemic, but that expired by its own terms. Vermont sick leave law applies to all employers, but it does not apply to all employees. So a farmer may be required to provide sick leave to certain employees and not others. It doesn't apply to employees who work an average of less than 18 hours per week. It doesn't apply to seasonal employees. So working in a job for 20 weeks or less, provided the job is scheduled to last 20 weeks or less. Basically, this is designed to prevent people from firing someone from a permanent position at 19 weeks and saying, I didn't have to provide you with sick leave. But it is designed to protect seasonal employers, including specifically when we were doing this legislation, the discussion was farms that have seasonal surges and ski resorts and other places that are seasonal there. And then you're not required to provide sick leave to anyone under 18. Nothing prevents a farm from doing it, but the only workers a farm is required to provide sick leave to are those who are working in long-term positions lasting more than 20 weeks, over 18 years of age, and working more than 18 hours, or at least 18 hours a week. So you're looking at basically half-time employees who are adults and working in a semi-permanent to permanent role. Question?
Sick leave in this case is it just job protection or is it paid sick?
This is paid sick leave. These are Vermont employers are required to provide 5 paid sick days, assuming an individual works full-time over the course of the year. So this is the paid sick leave requirement. We'll talk about family and medical leave in just a second, which is the unpaid long-term leave.
Because that's simple.
Yeah. And federal law here, no requirements. So this is a simple difference here. The family and medical leave, it applies to some employers and some employees, and the federal and state law are different. The bottom line, though, with these is that you're looking at 10 or more 3/4 time or more employees. So essentially almost full-time employees. And you have to have at least 10 of them for parental leave under state law and 15 for medical leave under state law. My guess is most farms in Vermont don't meet that threshold. There are probably some that do, but many will not. And then the employees, in order to be eligible themselves for, and this is job protected leave for the birth of a child or care for a family member that's sick, or because you suffered an injury. But the farmer is not required to pay you during this time. You have to have worked for them for at least a year and an average of 30 hours a week or more during that year. So there are going to be a lot of employees, even if you have a farm that's large enough to qualify, you are likely to have a lot of employees who don't meet the threshold. The federal law sets an even higher threshold of 50 plus employees in 20 plus calendar weeks during the year. So this is very unlikely that we have Vermont farms that reach this threshold. We have very few employers in the state, period, that reach this threshold. And then the employees, in order to be covered, you have to have worked for at least 1 year and worked 1,250 hours or more in the past year. So the federal law is a very, very small subset of Vermont workers because our businesses are so small here.
Could you repeat the size requirement again?
50 plus employees working in 20 plus calendar work weeks. So they look at the calendar work week and did you have 50 plus employees in that week? So if you have a 10-week surge where you go over 50, federal law doesn't apply. You may be subject to the state law though. All right, next protection is for nursing mothers. These, both Vermont, well, in Vermont, it applies to all employers. And you have to provide a reasonable amount of time in a private location to express breast milk for at least 3 years after the birth of the child, or for 3 years after the birth of the child. The federal law applies to employers covered by the FLSA. So again, the smallest farms are excluded there. And there you're only required to provide reasonable time in a private location for 1 year after the birth of the child. So in this case, because Vermont sets a higher standard, that's the rule that would apply to farmers. And so all farms would be required to provide a space for lactation for at least 3 years. Workers' compensation, this is state law only. It does not apply to farms that have an aggregate payroll of less than $10,000 per year. So our very smallest farms here are excluded. And then if you are not in that small exclusion, you're required to provide workers' compensation insurance for all of your employees, regardless of whether they are short-term or full year. This can be complicating for the employer because typically you purchase a 1-year policy. I don't know how this plays out for farms, but from hearing testimony over the years, I know that this is a complicating issue for businesses that have a seasonal surge, trying to right-size their policy so they're not paying for workers who aren't on the payroll for a significant portion of the year. And it also runs into complication where you see businesses going by the number of workers when they purchase the policy, not understanding that it may not cover the workers they hire on 6 months later, et cetera. So this may be an area that's worth looking into. But farms really aren't, apart from this exception for the smallest farms, they run into the same issues as other smaller seasonal employers might run into, that may not have the benefit of a full-time HR person who can help navigate this for them. So unemployment insurance, this is an incredibly complicated area. The simple way to think of it is this is a state-operated program that is subject to federal requirements. That is an oversimplification. One of the issues to keep in mind with these federal requirements is that we are following federal definitions of agriculture and coverage here. So we have somewhat limited control, and I would need to do some work, additional research and work with our counterparts at Vermont DOL to see where we could move if this is an area where you think the state law should be adjusted. Because one of the difficulties here is if you bring your state law out of compliance with federal requirements, there is a federal unemployment tax, and we get a 5.4%. So it's I think it's a 6.2% tax, and you get 5.4% of that taken off. So it becomes a 0.8% tax at the federal level. And if we go out of compliance with the federal law, we lose that tax exemption and we lose the federal funding for our department that does employment security at Vermont DOL. So it's a very significant penalty for falling out of compliance. So any changes we make, we always have to make sure that they comply with the federal requirements and don't bring us out of line with what the federal government says that we have to provide. With that being said, it applies to farms that pay $20,000 or more to agricultural workers in any calendar quarter during the current or preceding calendar year. So these are larger farms for Vermont anyway, or employed 10 or more individuals in agricultural labor on at least one day in 20 different calendar weeks during the current or preceding calendar year. That's more likely to catch Vermont farms than the other piece. Separately, workers who are employed as part of a crew that provides services to a farm are considered employees of the crew, and then would have to be covered under unemployment insurance for the crew, whoever the crew leader is or business owner for that crew would have to provide that unemployment insurance. So this could be folks who travel around doing services like fertilizing, potentially mobile slaughterhouses, things like that. In that case, those are not employees of the farmer, they're employees of the person who owns the business. And that is another point where there's potential complication here because there are questions of, are you a contractor or are you an employee?
Senator Ron Hinsdale, do you have a hand up? I see you.
I was going to put my hand up, so yeah. I don't know if this was the last UI bullet point.
This is it. Because this is so complicated, I didn't want to go too far down the rabbit hole today, but I'm happy to take questions.
Yeah, our committee goes very far down the rabbit hole, but I was just curious if DUA, so disaster unemployment assistance, was automatically included those who are not citizens. And if, I know all of this has some contingencies. So, we've gone really deep with DOL when we know that someone who doesn't have citizenship has no eligibility for some kind of hazard pay or unemployment benefit, but also is DUA generally included in what we're considering UI here?
So DUA is a separate but related program. It's a federal program, so you need a federal disaster declaration for it to kick in, and then it's subject to federal requirements. And I am not remembering all of the details, but I believe that if you're not, so I know unemployment insurance specifically excludes H-2A workers, so workers who are here on a temporary work visa, but are not citizens, are specifically excluded from unemployment insurance. DUA, I believe if you are not a citizen, you're excluded, but I'm not 100% sure on that. We probably want to get in someone from DOL to comment on that because they essentially administer that on behalf of the federal government. And it is a slightly different set of requirements. And it's also federal dollars that come out of, I forget which budgetary stream, but it's specifically set aside for DUA. And it doesn't come out of our unemployment trust fund. So what I'm talking about are essentially just the funds that come out of unemployment insurance. But that you're raising a really good point in that unemployment insurance for workers who are not citizens of the US is a much more complicated piece. And I left out the specific exclusion for H-2A workers, who I know are used by a lot of Vermont farms. So if they lose their job partway through their contract, they are not allowed to claim unemployment insurance benefits. I see another question from Senator.
Senator Brown.
It would be helpful at some point to look at a matrix of how these various things, and unemployment is one, discrimination procedures are another. To look at how it applies to various categories of people. For example, those who are citizens, those who are not citizens but are in the United States lawfully. And again, that may vary by programs if you're talking about H-2A, but for the person who's a green card holder, for example, I would expect that unemployment insurance might well apply to them, but I don't know for sure. And then there are those who are not in the United States legally. And the whole issue there is whether employment applies at all, because I think we need to understand all of those various issues.
And that is, we're going to touch on the H-2A program slightly at the end of this, but it is worth noting that that is an exceptionally complicated and gray area of the law. So there have been a number of cases that have addressed this, but it's not all settled law yet, to the best of my knowledge. One of the things I am planning on doing before a future meeting is updating the case law notes I have that I took several years back when I was asked this question the last time. So one of the issues for an undocumented worker in the United States is typically under labor and employment laws, one of the remedies you get if you've been retaliated against and fired by your employer is you get reinstated in your job. There was a holding in a case called Hoffman Plastics that dealt with the National Labor Relations Act. And it dealt with a plastics manufacturer that had undocumented workers who had raised an issue, filed a complaint, and then were fired for filing the complaint. And they argued that they were entitled to reinstatement. And the court essentially said, you're not legally allowed to work in the United States, so we cannot legally reinstate you. So in that case, that precludes at least some of the remedies under some of these laws. The EEOC has previously taken the position that the non-discrimination laws apply to everyone, regardless of whether you're here legally. There is a private right of action under both state and federal law that allows you to seek monetary damages in addition to things like reinstatement. So a court may not be able to provide you with, say, reinstatement, but you may be able to get your lost wages and other monetary damages. There is also the complicating factor of just the issues around undocumented workers and filing a complaint. And then the potential that you've now drawn attention to yourself and you're going to face repercussions from federal law enforcement. And then with H-2A, there are specific exclusions from certain federal protections for those workers, while the program also provides other protections. And then with that program, there are criticisms about whether or not the protections are actually effective or whether they're just creating sort of additional bureaucratic burden for limited benefit to the workers. And that's been an ongoing discussion. And I'm sure you'll hear from advocates about how that plays out. And then migrant and seasonal agricultural work, which we'll talk about, applies to migrant and seasonal workers, provided you're not an H-2A worker, and that provides other protections. So you do run into some particular complications. And then the last one, which is worth noting, and which we do not have a lot of case law on, is we have federal case law. There is very limited Vermont case law on how it plays out with these different categories of workers. And so that raises an additional complication there. the Vermont courts don't necessarily have to follow the federal courts when they're enforcing state law. And so we don't know what the folks next door would do if they got a case from a worker who's here on a visa or who is here without documentation and working on a Vermont farm, and they raise a complaint under one of the state laws. We don't know what our Supreme Court would do with that complaint, or our superior courts. And so I think we've got some questions that are out there. So I'll try to put together a sort of overview, but I just want to flag that this is an area that is still evolving, and where we are likely to see changes and additional complications as time goes on. I mean, the other issue that I'm sure all of us are aware of is that different parts of the country, different circuit courts, strongly disagree with each other on some of these issues, depending on the sort of political and ideological bent of the judges and justices, and depending on when they were appointed and who the president was. So you'll see sort of a divergence to the left in some circuits and a divergence to the right in other circuits. And then some circuits, even if they were appointed by the same president, they just don't agree with each other. And the Supreme Court has given us limited clarity on these issues. Although, again, we may see more of that coming. One of the difficulties, I think, with particularly the workers who are here, either undocumented or here on a temporary visa, is a lot of these cases don't make it to the high level. Because for undocumented workers, they may face deportation. And then for the temporary workers, they may not have the financial means to pursue the case or the time. When that visa runs out, you may face an issue that the issue's just moot at that point. So, but I'll try to give what clarity I can, with that caveat that there's not a ton of clarity, and some of these issues are still being figured out.
Representative Chestnut Tantrum, did you have a question?
No, I'll pass.
Okay. I know we're running a little bit over.
We're almost at the finish line here. Do
Just
you
before-
want to
No, what?
just finish before lunch, or?
Go ahead and finish. I know there's a couple more slides. I wanted to just ask, though, for clarity on this slide, that you have said applies to farms that pay 20,000 or more. Did you do that because it doesn't apply to other types of businesses, or is that $20,000 figure apply to?
So that's specifically for agricultural employers. And it's worth noting that the definition of agricultural employer here may not be entirely consistent with the definition in the FLSA or the definition for purposes of workers' compensation, et cetera. And this is one of the other factors that complicates this, is each law seems to get its own definition and there's slight variations. That's another matrix that could create is, what is it generally covering? But that specifically is for unemployment. This is the specific carve out that they created. So.
Okay, let's go ahead then.
Okay. Well, that brings us to the Federal Migrant and Seasonal Agricultural Worker Protection Act. An easier shorthand is either Agricultural Worker Protection Act or AWPA. So the first big requirement here, and I'll just go over sort of the major points, are that it requires farm labor contractors to register with the USDOL. So if you are a contractor that has a crew that travels around the country picking various types of fruits and vegetables, you have to register with the USDOL. You have to identify who the workers are that work for you. And there is a USDOL database of all the contractors and all the workers. I don't know how up to date it is, but there is a database so that if you are contracting with someone as a farmer, you can verify that the workers and the contractor have been properly documented and registered. Employers are required to pay the wages when due and provide written itemized statements of the wages, including any deductions. So for example, if you're providing food and housing and you're taking that out of the wages you pay to your workers, that has to be itemized so the worker can see, I earned so much for my work in the fields, and then these were the deductions, and this is what my check should be. Any housing you provide has to meet federal and state safety and health standards, and the terms of occupancy must be posted or provided to the workers so that they know what the grounds are, for example, for eviction or what you're promising to provide. The federal and state safety and health standards, that's an area that you may want to have more discussion on. It's been an area of controversy in the past as to whether housing meets these standards or not. But the standards, I think, are clear. The enforcement maybe has been something that's been questionable. At times, again, this is something where I'm drawing from general commentary on these laws. I cannot provide you with any specific commentary. Certainly no specific commentary on a Vermont farm. This is general national commentary. So I want to be clear about that I'm not stating that any Vermont housing is below health and safety standards. Vehicles used to transport workers must be insured, operated by licensed drivers, and must meet federal and state safety standards, seatbelts, airbags, brakes, state inspection, et cetera. Employers have to disclose employment terms and conditions, and they also have to maintain payroll records. So if you're working under this act, you have to meet all of these standards. It does not apply to H-2A workers. So this is essentially crews that are not here on an H-2A visa. And a migrant worker is someone who cannot return home at night. A seasonal worker is someone who can return home at night. So you may see both in Vermont. You may see crews that travel across multiple states. You may also see a crew that works multiple Vermont farms and then they go back to their house every night. Federal H-2A program. So this permits farmers to employ temporary non-immigrant workers on an H-2A visa if the employment of U.S. workers will not be adversely impacted. What does that mean? So that basically means that the farmer has to be able to show that they are not able to fill the position with domestic workers and that they made a good faith effort to advertise that position through two different means. One is through the U.S. Employment Service that will post these, and then the other is through some sort of local advertisement. Radio, newspaper, now online would be a possibility. And that when they've posted the position, they can't get enough domestic applicants. And so then they go through the H-2A visa program where they work usually with some sort of broker or someone like that who helps connect them with workers. My understanding is that oftentimes a farmer will continue to have the same H-2A workers come back for a couple of years. I believe, and don't quote me on this, I believe that as a worker, you're allowed to get a visa for 3 consecutive years, and the visa is for a period of months, but not the full year. You have to return home before you come back. Farmers have to pay the cost of transportation to and from the worker's home. They have to provide housing at no cost to workers who are unable to return to, I believe it's their permanent residence in the same day, but I'd have to double check that. They have to provide transportation from the housing to the work site. They have to pay workers at least twice a month. They have to ensure that transportation and housing meet certain safety standards and health standards for the housing. And they have to offer workers an employer-provided housing 3 meals a day or free and convenient cooking facilities that they can use. And that's the end of the presentation. So those are the standards. Again, the H-2A program has, I know it's utilized. I don't know the details of Vermont utilization. It has definitely been the recipient of criticism from both advocates for employees as well as from farmers who utilize it or feel that they can't take on the administrative burden of utilizing it. And there have been a lot of questions raised about whether some of its requirements are more bureaucratic than effective. Particularly things like the job posting requirements, where there's extensive documentation that's required of the farmer. But the question is whether it's actually reaching their labor pool with the things that are prescribed in the documentation. I don't have any experience to comment on that. These are just general criticisms that are levied on sort of a national level. And I can't speak to how it's affecting your Vermont workers, but they may be things that you want to ask about as you're looking into this more. So that sort of brings us to the end of today. Again, with the federal laws, I should also emphasize, we can't change those laws. But it may be something that affects how you want to shape the state laws that you can't affect here. Or you may want to just say, we can't affect those, let's focus on what we can affect. But that's entirely up to you as a committee when you're trying to figure out what in this extremely broad area do we focus on in the next 5 meetings.
One of the frustrations that we had when we looked briefly at the end of the session at some of these regulations and laws was not being able to get any numbers, any quantifying information on how many farms or how many employees fall into this category. For example, how many farms are there with more than 5 employees versus fewer than 5, or and then you start looking at seasonal workers, undocumented workers. And the state doesn't collect that information. And we established the Agency of Agriculture does not collect that information. I'm not sure about the Department of Labor, how much help they might be, whether any of the organizations that perhaps will be speaking with us might be able to help there as well. But just in thinking about, how do we prioritize? Where does it matter more? That information wasn't anything we were able to get quickly at the end of the session anyway. And I'm not, that's just an observation and a comment that I was thinking. We are, maybe it's a good place to pause take a break for lunch. We finished the employment law overview, I think, Damien, and then after lunch, we'll start looking at the collective bargaining laws. Is that your plan?
Yeah, after lunch, I'll focus on collective bargaining. And I think that'll probably take us up to close to 3 with any luck. We'll get through it a little faster and then we can even finish up early after your committee discussion. But yeah, that's the focus. One follow-up just to your comment on getting the information. That's another complicating issue with this, particularly for these federal programs like H-2A. You have multiple agencies administering it. And so USDOL, for example, is supposed to be looking at the labor standards, but the Immigration and Naturalization Service is administering the visas. And you run into issues of complicating guidance and unclear enforcement. Which can also add complications to this whole area here. One of the other things you may want to look at with your Vermont laws is, so we have the Agency of Agriculture that enforces agricultural standards. For the laws I just covered, things like discrimination are enforced by the Attorney General. Things like wage and hour and unemployment and workers' comp are generally enforced by the Department of Labor, although workers' comp also has enforcement by Department of Financial Regulation. And you also have the Labor Board coming into it when we start talking about collective bargaining. So you may also just want to think about, we already know the federal law is set up with some very convoluted enforcement streams and limited enforcement options, or potentially unclear guidance as to who's in charge and who you can get an answer from. With Vermont law, where we can make changes, does the overlapping enforcement of these laws work? And so forth. So these are maybe some bigger existential labor law and employment law questions here, but it is just another thing to keep in mind that you do have multiple entities dealing with this. And if they're not working in concert, you can sometimes run into gaps or challenges on, regardless of whether you're a person trying to assert rights or you're a person trying to follow the law and figure out where you can get clear guidance on what that is. So.
Do you know, Dan, the H-2A visas, are they always arranged through a broker?
I don't know. That's my understanding is that they predominantly are. But I don't know enough. Again, that's something your advocates who work with folks who are here on an H-2A visa or work with the farmers who are seeking out H-2A workers can probably provide you with a lot more depth on. There may also be organizations in the state who help link farmers up with H-2A workers that you may be able to get to come in on that issue if you want to look into that deeper. But these are things where I don't know enough about federal immigration law to know how that program plays out. And we do have other H visa programs that play out in Vermont. And so it'd be important too that we're not looking at H-2B, which is like workers at ski resorts, or H-1, which are workers in specialty professions that there are not enough Americans with those skills. And they all have different requirements and different processes to add to the confusion. And I've just scraped the surface of H-2A. Just to be clear, I've very, very little expertise in that area. So.
Thank you.
All right, any other questions?
David,
Yes, go ahead.
thanks. So, I mean, just to put a pin in this for future witnesses and testimony, my sense from our experience working with DOL is a lot of these are complaint driven, and it would be helpful for them to come in and report to us how many complaints they've had and what barriers we can identify with them to filing a complaint, what languages, they are able to provide information in or require information in, hours that people might file a complaint, etc. And just also, some of you probably know him wearing different hats, but at least I'm looking at Senator Brock, one of our biggest experts on this in the legislature, especially in terms of H-2A, was always Representative Will Stevens, who now is, unless something's changed, Senator Sanders' agriculture liaison. And I still don't know anybody who knows more than he does about the interplay between state and federal law around agricultural workers, particularly H-2A. So it would be nice to get him in as well.
Good, great. Make a note of that. Okay, let's stop there, take a break for lunch. We'll pick back up at 1:20.